Hey guys, this is Ben from Cut Law. Today we are going to talk about service of process. The legal process does not start until the writ of summons is served onto the defendant. You can watch one of the videos I did on what is a writ of summons. Now, Order 10, Rule 1 of the Rules of Court provides that the writ of summons has to be served by personal service. What is personal service? Personal service means you actually have to, the court clerk or the process server or the solicitor's clerk actually has to personally hand the writ of summons to the person, hand it to him personally. The process server or solicitor's clerk will have to do two attempts, one on a weekday, one on a weekend. If he cannot find, for example, the person is not home during the two visits to serve the writ of summons, then the lawyer can take out an application called summons for substituted service. What is substituted service? It means instead of handing the writ of summons personally to the defendant, they will usually get a court order to paste the writ of summons on his door. Once it is pasted on the door, it is deemed to be good service. So even if you didn't see it, the dog ate it or somebody tears it up, it doesn't matter. Once it's pasted on your door, there's a court order to paste on the door. Okay, it is deemed to be served and you have 8 days to enter an appearance. On the subject of substituted service, the lawyer can also get a court order to serve the writ of summons by email, by WhatsApp, even by Facebook. And another way of serving documents is to serve on another lawyer, the lawyer acting for the defendant. But the lawyer acting for the defendant has to agree to accept service of process, that means serve. If the lawyer for the defendant, the person getting sued, agrees to accept the writ, then the plaintiff's lawyer, the person who is suing, can serve the writ using the online platform called e-litigation. Now let's talk about service on companies. Under the rules of court, service on companies is sufficient if you leave it at the registered address. The registered address of a company can be found in the ACRA search, Accounting and Corporate Regulatory Authority. So you just do an ACRA search, the registered address of the company, and then you leave a copy of the writ there. Writ of summons can also be served on a company by registered post. Now, upon service of the writ, it is very important to file this document called a memorandum of service. Why? Because it is basically a document confirming that you have served the writ. If you do not file this document called memorandum of service and the person ignores the writ, you cannot enter default judgment. Default judgment means you win because all the allegations are admitted. You cannot enter default judgment against the defendant. A law firm once issued a writ of summons against one of my clients, and they forgot to file a memorandum of service, and they had the audacity to send me a 2 days email, because under the Legal Profession Act, before you enter default judgment, you have to give the lawyer 2 days notice. They had the audacity to give me a 2 days notice when they forgot to file the memorandum of service. Also, they didn't even count the days properly. The 14 days starts from the end of the 8 days to enter appearance, not from the date the memorandum of appearance was filed. So thanks for watching this video on service of writ of summons. Don't forget to click like and subscribe.